So my name is Terry Lawson. I am the Executive Director of Unlocal. And I am here with the Pro Se Plus project. And I'm going to explain what that is in a few minutes. We are very excited to have you here today and to have the folks online. And I'm going to just walk you through our agenda for today. So we're going to discuss what the Pro Se Plus project is. We're going to do a review of a very, very basic review of the US immigration system. We're going to talk about some of the very specific steps in the ICE check-in process and in the what are called EOIR hearings, but also known as immigration court. We're going to talk very, very briefly about some asylum policies and procedures. Today's training is not to teach people how to fill out their asylum applications, but rather to touch on that a little bit so that we know, and we will have future trainings on that topic. I'm also going to cover some frequently asked questions because there's a lot of questions that we have all together, and so we're going to cover some of those as well. Right now, the slides are in English. As we speak, they are being translated into Spanish, so I can provide Spanish translated slides later, not today. And we can. It's an issue with the interpretation. Oh, it's because of that. That's what's happening. That way you can see. That's showing up for the panels, but not as the. So now, can people on Zoom see it? I'm just checking with our folks on Zoom while we're checking something.
They can see the screen.
They can see the screen, okay. Okay, so we're not gonna do the full screen view because we want to make sure everyone can see it. I will try to make it a little bit bigger.
Lo voy a poner en Zoom a donde hay interpretación. Puede traer la niña.
Okay. Can we start again?
Yes.
Okay. So we're going to cover what is the Pro Se Plus project, the review of the U.S. immigration system, ICE check-ins and EOIR hearings, asylum policies and procedures, and frequently asked questions.
Buenos días, good morning. Soy Félix, el otro intérprete. Si pueden cambiar su canal al A para ver si me escuchan. Please change your A channel right now. We're in a different channel and you should be able to hear us. Perfect. Thank you.
Okay. So what is the Pro Se Plus project? So we're going to talk about that first. So the Pro Se Plus project is a project that involves several community-based organizations, Unlocal, the Catholic Migration Services, MASA, the New York Legal Assistance Group, Central American Legal Assistance, Venezuelans and Immigrants Aid, and African Communities Together. And if you are from one of those groups, can you please raise your hand? Yes. So we have some of those groups represented here today. So there are 4 main components to the Pro Se Plus project. The first is community education, in which we are talking to people who are seeking to file applications with the immigration system or who are in immigration court. We're teaching them what they need to know before they file their applications and when they are seeking to represent themselves in immigration court. So there's a list here of the things that we are teaching people: how to fill out their asylum applications, how to write declarations or affidavits, how to prepare country conditions, how to apply for work authorization, and how to represent themselves at trial and how to avoid scams. So that's the big piece of community education, and it takes place in a setting like this, where we are speaking in rooms or over online and teaching people in big settings how to do these things. We are also doing supporter trainings, and that's what this is today. So we are providing trainings to help people who are supporting those who are seeking some kind of remedy from the immigration system, helping teach people how to understand what eligibility requirements there are, what the steps are, what the policies are, how to fill out certain forms. We're not going to do that today, but how to fill out certain forms, and how to represent, how people can know what they need to know before they go to immigration court, and what some best practices are. So that's our second component. Our third component is doing screening and what we call triage for people who have recently arrived, to explain to them how, or first of all, to learn what it is that they need help with. So we are doing a lot of screening in a lot of different ways, and that is something that we are still working out. But mostly right now, the way it's happening is people are contacting each of these organizations. Unlocal has a hotline. MASA, I'm sure, it has many ways that people reach out. Central American Legal Assistance offers a phone line that's open Monday through Friday, 10 a.m. to 4 p.m., where people are calling and they're getting screened and provided advice and counsel. So there are many different entry points at this time, and we are working on getting those made public to walk. We are not there yet, but for each organization's hotline or intake information, you can visit their websites and their social media. We are doing this in coordination with our community partners, as I've said, not just the partners that are part of the Pro Se Plus project, but around the city as well. And we are working to develop cross-referral mechanisms, understanding that there's a lot of limited capacity because we just don't have enough money to cover all of the needs. So the fourth component is providing pro se assistance. So pro se means that the person doesn't have a lawyer and they are representing themselves. It's like a Latin term. I don't speak Latin. I just know it means you're representing yourself. So what we are doing in providing that pro se assistance is we are teaching people what they need to know if they're not going to have a lawyer, what they need to know when they're filing something, when they're representing themselves, and when they're going to their check-ins. We are also providing advice and counsel, which is similar to pro se assistance in the sense that we are letting people know what they might be eligible for, what they should not apply for based on our advice. And that often goes hand in hand with pro se assistance. We are also, to the extent that we can, providing representation as part of our regular practice. So now we're going to move to the second part of our agenda, which is reviewing the US immigration system. So this is a photo that I took of USCIS. Some people may have been in one of those rooms before. This is the room, one of the rooms where they are having people wait for their interviews for various things. Okay, so this may seem a little bit basic, but we think it's really helpful to go over these steps when talking about immigration, because it gets very confusing and it's not done the normal way. Immigration in the US is not done the way that this is broken up, which I'm going to explain. So we know that Congress, the Senate and the House of Representatives, they write US immigration law, they pass it, the president signs it. So that's the congressional piece. That's one branch of the government. The other branch of the government, the second branch is the executive. So the executive is responsible, and that's the administration. So that's right now President Biden, the cabinet officials, that's all, when we talk about the executive, that's all under President Biden. They are responsible for implementing US immigration law. And this is where it gets confusing. So they have under President Biden, the Department of Homeland Security and the Department of Justice and the Department of State and many other departments. Each of those has a role to play when it comes to implementing immigration law. Then we have the courts, which interprets US immigration law. However, and we're going to talk about this, the courts that interpret US immigration law are not what we're talking about when we talk about immigration court. And that's what's very confusing. And it's something that I often get tripped up on regularly. But when we're talking about the courts, we're not going to talk about the courts under the federal government today very much. But obviously the Supreme Court is there. So when the Supreme Court is saying like DACA is okay to go forward, that's what I'm talking about when I say interpreting US immigration law. Also the federal courts, district courts, appellate, like Second Circuit Court of Appeals. But we're not going to talk much about that today. Okay, so reminder, Department of Justice is under the president in the administration. In the Department of Justice, which is an administrative agency, it's not a court, but it's also where Merrick Garland is right now. It's the Attorney General's department. So under the Department of Justice, we have the Executive Office of Immigrant Review. That is what we mean when we say immigration court. And there we have those judges, they are judges, but those judges are appointed by the president and his or her cabinet members. They issue removal orders and they have the power to grant immigration status. So that's EOIR. We often say EOIR, some people say EOR, or immigration court, but it all means the same thing. There's also something called the Board of Immigration Appeals. So if you lose at immigration court level, I'm going to call it immigration court for the purpose of today, because that's what I call it in my daily life. If you lose at immigration court, then you can appeal your case to the Board of Immigration Appeals. But if you lose at the BIA, we call it the BIA, then you don't have any other place to go under the executive. So they have to leave that system and go into the courts. And that's complicated. We're not going to get into that. Okay, but we're going to come back to immigration court, but I want to focus now on the Department of Homeland Security. So the Department of Homeland Security has a couple others, but these are the main ones we're going to talk about, the main agencies under the Department of Homeland Security. We have Customs and Border Protection, also used to be called Customs and Border Patrol, or CDP. We have Immigration and Customs Enforcement, which we call ICE. And we have U.S. Citizenship and Immigration Services, or USCIS. So those are three separate agencies that are all under the Department of Homeland Security. So Customs and Border Protection is responsible for doing border apprehensions, deportations, and detention at the border. And they are also the people who are doing the fingerprinting. They are taking the biographical information. They are verifying people's information. And they are also assessing whether someone has permission to be in the United States. So they're looking at, can you go back? Yeah, that's okay. So they are looking at whether someone has permission based on what they are bringing in, and they manage the ports of entry. So the port of entry is, we're not going to get into that too much today, but it's where people can present themselves to ask for permission to come in. They're also patrolling the areas in between and apprehending people that way. So Immigration and Customs Enforcement is more like the internal agency. It's like CBP, but it's more internal to the United States, so less at the border. So, but they are also doing arrests and detention within the United States, and they are prosecuting removal proceedings. So if we think about a criminal case, and this immigration law is civil, but I'm just using the word prosecute because it feels like a criminal case. But if you're thinking about having seen on television, criminal proceedings, there's a prosecutor, right? There's a district attorney. That is the role that ICE is playing in an immigration court. They are also doing supervision. So if somebody is inside the United States, like not at the border, and ICE knows that they're here, they are supervising that person being, that's their word, not mine, that person being here. And that's why there are ICE check-ins. So we're gonna talk about ICE check-ins. And they are also effectuating removals. So they are removing people from the United States. The third agency is USCIS, or US Citizenship and Immigration Service. This is where affirmative applications are being sent. So work authorization applications are being sent there. Asylum applications, if someone has not been in an enforcement posture, and I'll explain what that means. We're gonna get into that. And it's where people will file for family members to come join them. It's where people file for citizenship. It's where people file for green cards, residency. It also covers humanitarian parole, which people have heard a lot about lately, and temporary protective status, and a lot of other things, DACA also. So I'm not gonna get into too much about USCIS. But I did want to show you some documents so that you have a sense of what documents you might be seeing when people are coming into your spaces. So the first document I wanted to show you, and I will provide these slides afterwards, so you don't have to, I know it's too hard to see right now, but it's called a notice to appear. We also call it an NTA. The notice to appear is a document that is issued to somebody to say, okay, you are being charged, the language that they use, as someone who is either inadmissible, meaning you should not be admitted into the United States, or as someone who is deportable, meaning maybe you had status, but now we are saying you shouldn't have status because you are deportable. So that's called an NTA. So that's like, to use a criminal context, it's like an indictment. It's like this is a document that now says, okay, you are now in removal proceedings. So, and it is a document that is issued by ICE. So, and that will come up, I'll explain why that's relevant later, but this is often a document that somebody has to know that they have a case in immigration court and they have to defend themselves from removal. This second document is called an order of release on recognizance. So if somebody is here in New York City and they've been given an NTA, a notice to appear in immigration court, they have probably also been given an order of release on recognizance, and we call it an ROR. And this also exists in other contexts. But what it means is that that ICE has said, okay, or CBP has said, okay, you can be released. You don't have to be in detention while you're waiting for your immigration court. You can be released. So, but you have certain conditions that you have to follow, and the conditions are in these documents that you have to report to ICE. You have to go to your court appearances and so on. This second page is something that people may see people handing them. It's often handwritten in these lines because this is what people bring with them to their ICE check-ins. And there is a place where there's a date, there's an officer, and a location to show this. It's a record that somebody has been checking in. Okay, so parole. So let's say you didn't get a notice to appear in immigration court, or maybe you did, but most times people are being issued parole and not getting an NTA at the same time. So parole can look a different way. There's different formats for it, and you see two different formats here. I've also seen other formats where it's basically like a permission slip. You can think of it. Someone saying, usually CBP, or you can see Department of Homeland Security, which oversees CBP, saying, okay, you can come in. What we've been seeing lately is the parole being issued for 2 months, which is a strange amount of time because nothing can really happen in 2 months, but it's a way of saying, okay, you can come in. So those people are not all being given notices to appear in immigration court. They're being given parole, and often a document that might look like this, called a notice to report. And a notice to report has their information, and it's kind of a newer document, so I'm getting to know it myself. The date somebody may have been apprehended, their country of citizenship, and who admitted them, and their biometrics. Then most of people are also getting something called a call-in letter. So the call-in letter has on it, okay, you are now in the United States. You need to be supervised by ICE. Here is information for you to check in with ICE. This is the document that tells people, okay, you now need to check in with ICE. Usually what we're seeing right now is that people are being told they need to check in within 60 days. So there's a document, the document will say where you need to check in, but it's often wrong. And we're going to get into what you need to do when you get when you're looking at one of these documents. Okay, so that brings us to ICE check-ins. Okay, so there is a timeline. I'm going to read it to you because I know it's small, but I want to explain the timeline again a little bit slower. So we looked at the documents. I was trying to decide which order to do things in. I decided to show the documents first and then do the timeline, but I could have easily done it the other way around. So somebody is released by the Department of Homeland Security. That's step one in this timeline. They're either given a notice to appear, which is what we just looked at, or a notice and order of expedited removal, which is something that someone receives if they either are ordered removed but still let in. I know it's a little strange, or they have an old removal order. They're given parole and an ATD, which stands for Alternatives to Detention. So that might be just explanation as to what is happening, that they are not being detained, but they have to check in usually, or a notice to report. So this is taken directly from ICE's website last night. It changes frequently, but last night on its website, ICE said these are the 4 things that someone could get if they're released into the United States. Then they are issued either an order of recognizance, that's that ROR, the release of recognizance document we looked at, or a call-in letter. So if you get one of these things, you're going to get an order of, if you are released under one of these conditions, you're going to be given either an order of recognizance or a call-in letter. This is according to ICE's website. The next step is to find the local ICE office. So most people are not staying exactly where they were released, right? They're moving either in Texas, Arizona, elsewhere, and a lot of people are coming to New York, as we know. So they need to then check in with their local ICE office. The call-in letter will probably not have their local ICE office on it. It'll probably have it's unclear why, but some people are just getting call-in letters for very random places. Michigan, people are seeing for no reason. So they really do need to find their local ICE office. And then here are the steps. We're going to go through them bit by bit, but I'm just going to summarize them now, and then we're going to go through them. They either need to attend their check-in, which is very difficult, which we'll explain why. Schedule their check-in because they may not have been given a time and a date to check in, or reschedule their check-in. And they need to do one of those 3 things within 60 days of receiving these documents. Okay, I know it's small again. It's trying to fit in a lot. I'm going to explain it what the remote ICE check-in steps are. So as we know, in New York, it is very hard for people to check in person, almost impossible. These are the lines that you're hearing about at 26 Federal Plaza. People lining up early in the morning, children out in the cold, terrible, right? So ICE has said, okay, we know that's bad. So here are some other options. These QR codes are ICE's QR codes. They have shared these QR codes, and I will share them in the materials after this, to say, use these QR codes to check in or reschedule your check-in in another way, so you don't have to appear in person. So first option, and again, this is all their information that I'm sharing with you so that you know that it is out there. So they have something called an ICE field office appointment scheduler. This is a website where, and this is, the website is checkin.ice.gov. This is the QR code, where you can schedule a future appointment. And I'm gonna explain this more in detail. The second step is you then can email ICE, or the ERO stands for removal operations, expedited removal operations, enforcement removal operations. They have an email address that you can email, and they've also provided a QR code for that. If you've been given a government phone or electronic device, there's a separate email to email, but the information in the email should include an A number, if the person has an A number, a current address, telephone, and it says on their website, but it's not strictly necessary, the FOAS appointment date and number. So I'm gonna explain what all that means. Okay, so here is the ICE enforcement and removal operations appointment scheduler with the website. This is what it looks like. This is what I logged on last night. This is what I saw. You need something called a subject ID, which is on this notice to report. So if you look at the top, you see the blue arrow and it says subject ID. You're going to be looking for this notice to report document. It's not going to say notice to report in blue like that, but you're going to look for a document that says notice to report, and you're going to look for a subject ID. It's technically called an I-385. That we think, we're not entirely sure, and I checked in with some colleagues about this last night, if the subject ID and the A number are the same thing. What I understand is that not everybody who's getting a notice to report is being given an A number at this point. So that's why it says subject ID. The thing is though, if you don't have a subject ID, you can't get past this page on the website. Because I tried last night and I couldn't get past it. So not everybody has their subject ID and not everybody has a notice to report. You can try putting in an A number. I don't know what will happen because I haven't tried it yet, but you can try putting in an A number and seeing if you can get past. Okay, so next step, if you can't get the ERO appointment scheduler to work, you also can email. So, and there's 2 different email addresses depending on whether someone got a government phone. So I wrote a little sample email for you all. It's in English, but it can be translated, although it's probably better to send in English. That just simply says, good morning, good afternoon. I am writing on behalf of person, A number if they have, who resides at address, their phone number is, their email address is. They are writing to satisfy the reporting requirements and to schedule their check-in appointment if required. Thank you for your attention. So there's a couple things I want to unpack in this email address. The reason that I am suggesting that people write these email addresses is that that requirement that I talked about having to check in within 60 days can be satisfied by an email like this. This is what we are being told. So we are being told, and I can't 100% guarantee anything that ICE says, but we are being told that if somebody sends an email like this, either from their own email account, who has to report, or one of you helps to help them send this, either you send it or help them write it and they send it. That should satisfy the requirement to check in within 60 days, meaning that they don't need to go to 26 Federal Plaza and wait in the cold. Any questions about that before I move on? Okay, so that's why I wrote this email address, or this little email. If you don't have all these pieces of information, that's okay. Put the information that you do have. You will receive if ICE is doing what they say they're going to doing, an email back that says, and I've seen them that come back that say, I see somebody shaking their head. So I'm not going to guarantee that they'll do this. I know that sometimes they do this. Sometimes they send an email back that says, you have satisfied your reporting requirement. If they're doing what they're supposed to be doing, that's what they should do. But as I am not at all surprised to hear, not always. The person themselves should also send the email, ideally, but you want to sort of have as many points as you can. There are two different addresses, two different email addresses here, because one is for, this is an NYC email address. One is for people who didn't get a government phone, and one is for people who did. When I say government phone, I mean ICE or CBP handed them a phone.
Do we need to know which is which, or send it to both email addresses to be safe, or like which email address is for someone with the device?
Yeah, so it's on this slide here.
It's the ATD alternative.
Yeah, so if they have been issued the government phone, use ATD. If not, use the other one.
I couldn't hear what you just said. Before that, can you repeat it so we can
Yes. What did I say? I was talking about the email address and was saying that there is an email. This is the sample email to send it to these email addresses.
Yeah, it was about the difference of the two addresses.
Yeah, so the top email address is if you have not received a government phone, and the bottom is if you have received a government phone. Okay, so those are ICE check-ins. Any questions about ICE check-ins? Okay, yeah.
I can imagine someone saying, to be safe, I'd better do all of them, send an email and go in person, and there's one other. Do you think that is a reasonable, safety net, or will that cause confusion?
I think it's not necessary. I will say one thing about the checking in person. I definitely don't think it's necessary to try to check in person, because what will happen when someone goes to check in person is they will be turned away.
Yeah.
And they will be given one of these email addresses and said, email this email address. There's one other thing I wanted to talk about, so I'm going to talk about it really quickly, which is that some people, and I saw these in the last couple of months, are getting these like pink sheets. Has anyone seen these pink sheets that has like an appointment date on it? Okay, so there may be you may come across these pink sheets that has your ICE check-in is now in 2029, right? Those pink sheets is I've seen them. I was trying to figure out where they're coming from. My understanding is that they're being printed at kiosks at 26 Federal Plaza. So for some people who are able to get into the building, they're still not checking in with ICE. There are these kiosks that are set up that are printing out, and the people I think are assisting them and checking in that way. And so they're not really checking in, they're just getting a new date for like 8 years from now. So I'm going to talk about that, what that means, because it's very confusing for people. Okay, but before I do, so what to do if an address changes? Yeah. So we know people are changing their addresses. Their addresses being put on those initial documents we talked about, the notice to appear, the ROR, the call-in letter, that are not where people are actually living. Some of that is because they changed their mind. Some of that is because ICE put the wrong, or CBP put the wrong address on there. So it's important that people change their address as soon as they move. Because if they don't change their address, they might miss something that they need in order to make sure that an order isn't issued against them. So there are 3 agencies that would need that change of address. Sending it to one does not satisfy sending it to the other. So they don't talk to each other when it comes to addresses. So I gave you the ICE. There's a phone number that people can call to change their, and this is all, again, from ICE's website. I said, call this, I checked last night, call this number to change your address. So I'm giving you the number they put on their own website. EOIR, remember that's the immigration court. that has a change of address form. But it's important to know which New York City immigration court somebody is in, because you have to file the change of address with the right court. There are 3 of them, 3 courts. You don't have to file with all 3 courts, but you have to file with the right court. It can either be mailed in or handed in and taken to the court. And then USCIS, the agency that does the affirmative applications, has their own form. So if you're changing your address and you want to make sure that you get anything relating to a work authorization, you have to file the change of address form with USCIS, which is also available online. Okay, so now we're going to talk, yeah.
If someone has not yet begun an asylum application or any process with USCIS, then am I thinking correctly that they would not need to file
Correct.
anything there? Like
Right.
I've done change of address with people and we just did the EOIR 33.
Yeah.
I mail it to wherever their old location is.
You could speak up so we can actually
Sure, yes.
translate your question.
I was saying, asking if I'm understanding correctly, that if someone has not yet begun an asylum application or any process with USCIS, that they don't need to file the AR-11 with USCIS. They would be still working with the EOIR
Correct.
address change.
Correct.
Thank you.
Okay, so let's talk about immigration court hearings. I'm keeping an eye on the time. So remember again, with immigration court hearings, and this is Heather Axford, who is the director of Central American Legal Assistance, doing a Pro Se Plus clinic on Wednesday at the Asylum Seeker Navigation Center. Just thought you might like to know that little fact. Okay, so let's remind ourselves again, EOIR is under the Department of Justice, which is separate from the Department of Homeland Security, but it's still all under the president and the executive branch. So EOIR, federal agency, ICE, federal agency, they don't work in the same department, but they are all still under the executive branch. Okay, so EOIR has its own hearing date. It has its own hearings, which are not the same as ICE check-ins. Different agencies, different requirements, different powers over people. So EOIR has a website. This is the website where you can log on and check somebody's hearing date, but you need their A number to be able to check their hearing date. They also have a hotline number, and this is the phone number that you can call. Same information. Actually, sometimes they're slightly different. So sometimes it's good to check both. They're supposed to be the same, but it'll tell you the court that somebody's in, the judge that they're appearing in front of, their next hearing date. It'll also tell you whether there's something called a clock. I'm not going to get into a lot of that right now, but it'll also tell you on that hotline how many days somebody has on their clock, which means whether they can file for employment authorization. But that's going to be for another training. Okay, there are 2 types of hearings at immigration court, or EOIR. There's a master calendar hearing, and there's an individual hearing. The master calendar hearing is like a preliminary hearing. It's like a conference. No trial, no evidence, but very important to attend, because if you don't attend, you can be removed, ordered removed. Same thing for the individual hearing. At the master calendar, there's usually a lot of people appearing at once on the master calendar. In the pre-pandemic days, you would go into an immigration court date on a master calendar day, and there would just be 20, 30, more than that, 60, 70 people in one room or spilling out, trying to just be seen for their hearing, master calendar hearing, which is like a 5-minute hearing. And it's where the judge says, okay, what are the charges? What is the country for, they ask for a country to be designated for where someone should be removed to. If they lose their case, they ask if someone has a lawyer. They ask what kind of relief that person is seeking. And typically, if not all the answers to those questions are provided because someone doesn't have a lawyer yet, they don't know what relief they're seeking, they are contesting the charges, then another master calendar will be scheduled to give time to answer some of those questions before an individual hearing date can be scheduled. So an individual hearing is the other kind of hearing, and that's like a trial. And those usually last about an hour to 2 hours. And they're on a different day from the judge's master calendar date. So the judges don't usually have, the individual hearings are not scheduled at the same time that they're hearing the master calendar hearings. At the individual hearing, it's like a trial. It's where evidence is presented. There's something called a call up, which people may have heard of. You have about 15 days, sometimes longer, before the hearing to submit all the evidence, right? So, and then it'll be reviewed at the hearing. That's where people testify, they have witnesses. And after that hearing, if the hearing is completed, because it may not complete on one day, it might have to be carried over to another day, the immigration judge will either rule like an oral decision, give their decision then, or say, I'm going to issue a written decision and then mail the decision. They can order removal. They can also order relief at the hearing. Right now there are two ways that people can appear. In person is one of them, and these are the 3 courts that I mentioned in New York City. And then also WebEx. WebEx is the remote option. Most judges in New York City offer both options. Some judges only offer WebEx. Very, very few judges, I have not come across this, require in person for everyone. We don't know if that's going to change, but that's the current situation. The website that I provided here gives you a list of the actual WebEx, because each judge has their own WebEx link that you can click on, and that will take you into their courtroom. So if somebody has a master calendar hearing and they're sitting next to you and they're like, I can't get to the court, it's probably better for everybody's health and safety, you can log on and they can appear via WebEx. People can also call in, I should have provided that. There's a call in option as well. But this website will show you what the WebEx address is, and it'll also show you the name of the judge, the clerk, and I think there's a phone number on there as well. Okay, so the notice of hearing is a different document issued by EOIR. We didn't talk about this earlier because I don't want it to get mixed up with the ICE and CBP documents, because remember, this is a separate agency. So this is a notice of hearing. I know it's hard to see. That was issued for one of my clients, so you can see my name on it. And this one actually is an internet-based hearing. It says on the hearing, which is kind of rare, this is going to be an internet hearing. It's going to be a WebEx hearing. This particular judge does not want anyone coming into their courtroom. So, and one thing I should say about that, just so people know, when I say it's a remote hearing, right now what is mostly happening is the judge is actually at the courthouse and their clerks are there and their cameras are all set up. They're just not having anybody in the room. So that can be a little confusing. Most of the time though, the ICE attorney, who's the prosecutor, quote unquote prosecutor, is at home. So they're not usually in person, is what we've seen. This notice of hearing is the document that tells people, okay, this is your immigration court hearing date. This is not ICE check-in, this is a different thing. This is, you have to appear at this date. If you do not appear, you will be issued an order of removal in absentia is what it's called. So you didn't come to your hearing, whether it was a master calendar or an individual, so therefore you were ordered removed. There are a lot of people getting these orders of removal because they don't understand that they have to go to this hearing, and it's not the same thing as their ICE check-in. On the bottom of this, and I just noticed this yesterday, you can see I did a lot of work last night on this. There's a QR code that I hadn't seen before. If you go to that QR code, it actually translates the notice of hearing into several languages. And so you can, not your notice of hearing, because it doesn't have your client's information, but it provides like a template, and they all look the same. It'll say like name of hearing. So you can actually use that. If people show this to you and they show you a notice of hearing that has this QR code, you can look at it and then it'll show you, I think it's like 9 languages. Okay, so most important takeaway. Anyone want to guess what it is? some audience participation. What do you think is the most important takeaway from what I've repeated a couple of times? Hopefully, somebody gets it, but it's okay if you don't. That's fun with more than one. Anybody want to say what they think is the most important takeaway so far? Come on, guys.
Be brave. I mean, one thing that the main thing that I'm getting that I didn't know before is how these different entities relate to each other. That's not necessarily the takeaway for the individuals themselves.
Yeah, that's getting there. Anybody else? Blanca, I'm gonna call on you.
Probably the functions of each of them, like ICE, EOIR, and then UCIS.
Yes, yeah, so they're separate, and here's why that's important, right? Because here's my version of the most important takeaway. Because the ICE check-in is not the same thing, does not equal, I was hoping people would get that because it's kind of small, does not equal attending an EOIR hearing. They're two separate things. So that is one thing that I want everyone to take away today. If you're meeting with anybody and they say to you, I have a nice check-in, it's not until January 1st, 2030, which is honestly what people are, January 2nd, 2030, which is honestly what people are seeing. Do I have to do anything else? If they get a notice of hearing, yes, they have to go to their notice of hearing. If they don't go to the notice of hearing, they will be ordered removed. If somebody happens to have, and this has happened, doesn't happen a lot, but if somebody has an ICE check-in in 26 Federal Plaza, again, doesn't happen a lot, and they also have an immigration court date in 26 Federal Plaza, if they go to the 9th floor, which is where the ICE check-in is on that day, but they don't go to the 12th floor, which is where the immigration court is, they will be ordered removed. So it's very important people to understand this. Okay, so I'm going to talk about asylum a little tiny bit. So there are two types of asylum. There is defensive asylum and there is affirmative asylum. For defensive asylum, people have to file it with EOIR, the Executive Office of Immigration Review, or Immigration Court, if they've been issued a notice to appear. So if somebody is in removal proceedings, if they are defending themselves from removal, and the EOIR has issued them a notice of hearing, or they've gotten a notice to appear from ICE, they have to file their asylum application with the immigration court. They can, it's better, you can mail it in, but it is better to go to the court and get a little stamp on there to show that you have met your 1-year filing deadline. The other way people can file it for asylum is what we call affirmative asylum. So they can file with USCIS. There are different addresses, so you need to look at USCIS's website to know which address to file. If they have not been given an NTA, or notice to appear in immigration court, and they're not in immigration court. But for both applications, both types of applications, one application is called the I-589, there's a requirement of filing within 1 year of entry into the United States, not in New York, but the moment that person crosses the border, that's the date of entry, and they have to file within 1 year of that entry. There are some exceptions, but that is a very important date to make sure people know. They also must fear persecution in their home country. They have to have a well-founded fear of future persecution. As I said, I'm not going to get into all that today. Okay, I'm going to talk also very briefly about employment authorization, because I have some frequently asked questions I want to go over with you all. But very briefly on employment authorization. So if someone has filed their asylum application, they, after 150 days have passed, for most of the time, they can apply for work authorization. Takes 3 months usually, sometimes longer, usually longer, for someone to get their work authorization. People are also eligible for work authorization if they have a parole document. However, they're only eligible for work authorization for the time that the parole lasts. So do you remember when I said earlier that people are getting parole documents for 2 months? That's not helpful when it comes to work authorization. So you have to have a parole period that lasts longer than it takes for them to process the work authorization. And it takes them about a year to process parole work authorizations. So we are doing a lot of advocacy right now to try to extend those 2-month paroles to longer. And so that is a to come. Hopefully we'll have some luck there. But right now, you can apply for work authorization if you have parole and it's valid. But you have to pay $495. Some people are also under what are called ICE orders of supervision. So maybe they have a removal order, but ICE, for whatever reason, has not removed them from the country. Some of those people are eligible for work authorization as well with something called an ICE order of supervision. And the form is called a I-765.
How would they know if they were eligible for a work permit under ICE supervision?
So an ICE sup order, the question is, how will they know if they were eligible for a work permit under an ICE order of supervision? We have not covered ICE orders of supervision, so none of the documents that I showed you are ICE orders of supervision. They are usually issued to people after they have lost their immigration cases, and it'll say ICE order of supervision on it. And so some people, depending on the category, are eligible. That they're going to need to consult with a lawyer to know. But it's not most of the people that you're seeing.
Sorry, can I just add one thing?
Yeah.
Kind of a side note. For those people that do have parole or do have ICE supervision, they can get New York State safety net assistance.
Yeah.
They can get. So even if it's for 1 month and they can get $100, nobody else is giving them $100 on the corner. So I always say apply and see what they can get when their parole ends. Also the same thing, the assistance ends.
Yes, so Blanca is saying that there's a whole host of options for people depending on their types of immigration status. It's super complicated. I'm sure Blanca knows it way better than I do as to what people are eligible for at what times. But some people, even if they've just filed an asylum application, are something called a person residing under color of law, could also be eligible for New York safety net assistance and Medicaid. But but hopefully Mercy Center is the place to go when you have those questions. Yeah.
Supervision. So if somebody does it matter how long the application takes for it to
So the question is, does it matter if someone lost their removal case? Can they get an ICE order of supervision? It doesn't usually work that way. Usually it's issued at the time of the removal as like a negotiated thing with the government. So it's not everybody who has a removal order is eligible for or will get an ICE order of supervision. That's where, and Unlocal is actually part of something called the Rapid Response Legal Collaborative. And I can share maybe we can make a note to do this. I can share the referral form for people and how to refer people if they know that they have an order of removal and they want to know how to reopen that or what other options they might have. Any other questions? Okay, so we're going to get to frequently asked questions. This is a photo of my colleague Eva here, and just a couple blocks away, we were at the Bronx Sanctuary Shelter doing a version of this presentation. Okay, so this is a big one, and I'm going to be honest, I was losing some steam last night when I was doing these slides, so I was like, I'm just going to talk on the next set, which is the frequently asked questions. And I've got a few of them here. Can we go to the next one, Candy? So there's going to be quite a few. There's about 6, and I'm just going to talk because things are changing all the time. And I don't have all the answers. So has anyone heard of CBP 1? Does anyone know what that is? Okay, that's good to know. So CBP 1 is a new application. So everybody knows what everybody remembers what CBP is, right? It's Customs and Border Protection. It's an app. CBP 1 is an app. It is an app that people are being asked to download and then input their information into as a way to manage their check-in appointments, as a way to get an appointment to appear at a port of entry. So I don't recommend that people in New York do this right now. There's really no reason to give even more of our private data to ICE on a phone. However, there is a lot happening in the next couple of months, and CBP1 is playing a role in that. So people may have heard there was an announcement about a week ago, a little over a week ago, about changes to asylum and how people can enter the country. Does anyone hear about these new changes? So I see some heads nodding. So and I'm gonna summarize them as best as I remember. But what the new changes say is, okay, Title 42, which is a law that has been being used for the last 3 years to keep people out of the United States on the premise of public health, has been struck down as a reason to keep people out because we are not in the same phase of the pandemic that we were in 3 years ago. So, but the government has given the Biden administration until May to put whatever mechanisms it needs to put in place before Title 42 is struck down. So right now, the Biden administration is still using Title 42 to keep certain people out of the country. The reason that we're seeing certain populations coming in, even though Title 42 exists, is because the US, for different reasons, has chosen or is unable to apply Title 42 to certain countries because of the relationships we have with those governments. So Venezuela is a country where we don't have a very good relationship with the government. We aren't able to send people back under our country agreements. And so that's why there have been a lot more people from Venezuela than from other places. So why am I talking about this? So the federal government has said, okay, you're going to say we can't use Title 42 anymore to keep people out who are seeking asylum. So we're just going to change the rules about how people can seek asylum. So under the Trump administration, there was a rule that was put into place that said if you traveled through a third country, and in this case, it's almost always going to be Mexico, and you didn't ask for asylum, therefore you can't ask for asylum when you get to us, right? The Biden administration removed that rule, but now they're putting it back in place because of this change to Title 42. So they're saying if you traveled through, and it's super complicated, and I've read these different versions of the rule, and I'm not going to be able to summarize them all here because I don't understand them all myself. But basically, part of this is the Biden administration is saying, if, however, you come and you want to apply for asylum, you need to download the CBP1 app before you get to the United States, and you need to put in a request for an appointment at a point of entry. So those are the entry points that the CBP manages. And if you get an appointment and then you present yourself, then maybe we'll let you apply for asylum, even though you traveled through a third country. But it's unclear what's going to happen there because they're kind of saying both at the same time. They're saying use CBP1 and third country ban, but it's unclear because most people have to travel through a third country and most people are not requesting asylum from Mexico. So nor is that what I think Mexico wants either. So, so when I say what's going to happen in May, nobody knows because this is a proposed rule. They had given a very short timeline for people to provide their comments. Comments are due by the end of March, even earlier, I think March 26th, 27th, if I remember correctly. So people are putting in their comments now, and it's very rare for the executive branch to issue a rule for people to comment on and then pass it a month later. That almost never ever happens. If you remember with public charge, there was a rule proposed and there was many, many months of waiting to see what was going to happen. We're on some kind of accelerated timeline right now. And what the Biden administration has said, but there's no reason why we would know if they're telling the truth or not, is that, oh, we're only going to do this for a few months because we want to see what happens when Title 42 is taken away. Of course, there's a lot of activity in the courts as well, that are sort of fighting on both sides about what happens with Title 42. But in any case, I just want people to know there is this app. People are being asked to download it. They're being asked to ask for appointments at ports of entry so that they can affirmatively apply, or they can say they have a credible fear of returning to their countries, and then maybe they'll be let in. But it's going to be very case by case, and we shall see what happens. Also, the app crashes a lot. And it's supposedly in multiple languages, but the error messages are in English. Okay, so my next question, frequently asked question. And I want to give credit to the folks at MASA for asking many of these frequently asked questions, which you're going to see here today. And I'm just going to do my best to answer them as I did with MASA a few weeks ago. So how does parole work and how does it get extended? So parole, as I said, is issued at the border usually. It's unclear how they decide how many months. For Ukrainians, it was more like a year. For Afghans, it was more like a year if they were able to get to that point, if they were at the southern border. And what we are advocating for is that people not have to necessarily, because some people are not eligible for asylum, and they don't really want to apply for asylum. They don't have a fear of returning to their country. They left for other reasons. So what we're trying to do and we're advocating for is that when somebody is given that 2 month, and this is just all my dream world, okay? I mean, my dream world is totally different than this actually, but what I wish would happen in this scenario is once somebody checks in, like emails saying, I'm here, I'm in New York, and then they get an email back from ICE that says, okay, you've satisfied your reporting requirement. What I want to happen, me, Terry Lawson, is them to also get an email that says, and your parole is now extended until your next check-in date. Because if that happens, then people can apply for employment authorization. And if they don't want to apply for asylum, they don't have to, right? That's my thinking. And that's what we're advocating for, actually. Yeah.
I have a question coming in from online. Under parole, will folks be eligible for a fee waiver for that work permit?
Yeah, we have looked into this. There are fee waivers eligible for people who, I'm looking at Eva because she does the fee waivers in her office. We don't do them a lot because it's very rare that you're going to see parole last long enough to get the work authorization, but they are fee waiver eligible. I looked into this recently. Yeah.
When you say you're advocating, who is advocating it?
We are advocating, when I say we, I mean like the partners of PSPP had a meeting with ICE like 2 days ago, National ICE headquarters, and said, you should do this. And they're like, okay, we'll write that down. So we are hoping that we get some traction, because it is in everyone's interest for people to work lawfully. If they're letting them in, they should just let them work lawfully and pay taxes and get out of shelters. And it seems to be a win-win for everyone. Not win-win for everyone, but better than we have.
Materials about this?
I'm sure there are. I don't have them, but I'm sure there are. Okay. Next question. Can someone apply for asylum if they don't have an A number? A number is a number, I don't like using the word alien, but that is the technical, it's called an alien number. But can someone apply for asylum if they don't have an A number? Yes, they can. They don't need the A number to submit the 589. And in fact, most people who are applying affirmatively, most people who are not in immigration court, who've not received an NTA, notice to appear, aren't going to have an A number anyway. So they can just fill out the asylum application with their name, address, and other data. Does someone have to wait to file, does someone have to wait for their court date to file for asylum if they have received a notice to appear? No, they can file their asylum application at the court. That's usually the best way, because you want to get a stamp on their copy. They should submit a copy and then keep a copy and have the court stamp the copy that says the date that they filed it, so they have proof of their 1-year filing deadline. But no, they do not have to wait for their court date in order to file for asylum. One question I didn't write, but I should have, is because this came up a lot when we were meeting with people with those pink sheets. They would say, okay, I don't have a notice of hearing date. I have my ICE check-in date. What am I, which is in 8 years, what am I supposed to do now, right? That happened, that question came up a lot over and over again. What am I supposed to be doing? People should, if they want to file for asylum, need to make sure their asylum application is filed within 1 year of their date of entry. Once they've done that, if they don't have a court date, they can just start to compile their evidence for their asylum application. So getting declarations, getting records. You don't want to wait 8 years to start looking for records. Things get lost, pictures are gone, videos and voicemails are lost. So they can just keep working on collecting their evidence for whenever they get a court date. Okay, this question comes up a lot in these kinds of settings, and I just wanted to touch on it briefly. How do we make sure that we're not engaging in the unauthorized practice of law? So, so I'm talking to you, I'm an immigration lawyer, but I think most of the people in this room are not immigration lawyers, which is great. That's what we want. So we're very happy about that. I do not want to, as an immigration lawyer, gatekeep that. I do not want to keep the information that I have from you all because you do not have an immigration, because you're not licensed as an immigration lawyer. I want you to have this information, but I also want to answer your question about how not to engage in the unauthorized practice of law, which is a very valid question, right? Because we know, especially here in the Bronx, how many people are taken advantage of by people who hold themselves out as being experts and then charge a lot of money. And the reason why I, Terry Lawson, feel so strongly about giving this information to you all is so that you have the information and the capacity to say to somebody, here is what I know. I am not a lawyer, but I can give you the information I know. I cannot give you advice. I cannot counsel you, but here's the information I know. So that somebody doesn't end up paying $5,000 to somebody who's going to file a fraudulent asylum application for them and get them a removal order issued to get the same information that you can give them, right? You're not going to give them advice. You're not going to say you should do this. You're going to say, here's the website that I know about. Here's the phone number that I know about. Here's the documents that I know about. And you can use that information as long as you are explaining to people, I'm not a lawyer. I can't advise you. You can also help somebody prepare an application, and there's a place on the application that says name of preparer. You are going to be saying, like, I help this person prepare their application. As long, you can do that. I mean, I do that for my mother-in-law, not as a lawyer, but I do it as a person who loves my mother-in-law, right? I can fill things out for people. I do it for my children all the time. So you can fill things out for people if they want you to, and they give you consent and you want to do that, as long as you're clear. I am not a lawyer. I can't give you legal advice. I don't know immigration law. I'm not licensed to give you that information. And you can also tell them, neither is that person over there who said that they were. Neither is that notario who said, that they could give legal advice. What should someone do if they do not have identification or ICE took their documents? This is a big one, and I'm gonna actually put her on the spot a little bit and ask Eva to talk a little bit about what we advise people when they're looking for identification. And they don't have identification.
So they don't have identification. So a valid ID will have to have a photo, the date of birth. Those are kind of two main components in that. Searching through any photos of documents that they might have kept will be helpful. But we do want to get them to get eventually an ID. So New York City NYC ID has been crucial with that, has been very helpful as of late. They accept the notices to appear as part of evidence for their point system to receive an NYC ID. So that's been a big change this year. We've also seen some success, especially with student IDs, with the Parks Department also has like IDs for their membership, especially using their tennis courts. And just any ID that will have a photo and the date of birth and the address. We also know organizations have created their own IDs, or local has an ID. We've added that into just creating those ID documents for folks. Yeah, those are the ones that we've been using.
So I'm just gonna repeat and summarize a little bit what Eva said. So oftentimes people don't have a government ID, and that can be a passport, but not everybody has a passport, right? So if someone needs a government ID with a photo, they can use some of those ICE documents that I just showed you earlier and take those to ID NYC offices, which is run by the mayor's office of immigrant affairs, and use that to get an ID NYC, and that is a government photo. There are some other things that they're gonna need to show that they live in New York. But there are different mechanisms for getting ID. I know it's hard, and we spend a lot of time, Eva spends a lot of time trying to help people through the steps of getting their IDs, and that's something that I'm sure people are asking you all for help with as well. If ICE took their documents, it can be very hard to get those documents back, almost impossible, but it is common that does happen. I know this is a big question. How does someone find a lawyer to help them with their immigration case? That, Blanca, go ahead.
Just to go back to the last one.
Yeah.
Yes, when ICE takes their passport, some people say, I'm going to my consulate and I'm gonna just for a new one. And can they actually do that? Because I believe they're supposed to report to ICE to ask permission to be able to do that.
That last part I've never heard before. So what someone was saying is ICE has taken someone's passport, someone decides they're gonna go to the consulate for their country in wherever city they're in. Can they do that? And Blanca was saying that they have to ask for permission from ICE. I have not heard that last part, so I'm not sure where that comes from. But the question of whether you can seek a passport from the country that you are seeking asylum from is a debated question. So people do debate this. There is no one definitive answer. If you're very risk averse like me, I would rather find another form of getting them identification rather than seeking benefits from the country that you say that you're afraid to return to. But people do that. So that's my answer to that question.
While we're on documents, I have heard that people are supposed to get their passport or things back from ICE or at the end of the court proceedings or something like that. Have you ever seen that actually happen?
No.
Thank you.
I know that they are supposed to, but they don't always get that.
I have a question coming in from someone who has not received a notice of appearance and does not have any kind of case log with an EOIR. Those are the folks that are able to file the I-589, the asylum application, online rather than that court window.
Correct.
And just to be safe in doing that before they're 1 year.
Yes. So just to repeat that question, if somebody has come through the border, has been processed at the border, but doesn't have a notice to appear in immigration court, so they might have an ICE check-in, but they don't have a notice to appear in immigration court, they don't have a notice of hearing, or some people are given notices to appear in immigration court, but their case isn't showing up in on EOIR's hotline or the portal. Actually, that happens a lot. So someone's been given an NTA by ICE, but the reason that happens is because ICE has to take that NTA and file it with the immigration court. And if they haven't done that yet, the immigration court will not take that person's asylum application. They will say, we don't know who you are. We know you have a notice to appear that ICE gave you, but we're not ICE, so we don't know who you are. So go file that with USCIS, the third agency. So just to make things even more complicated. But yes, if someone is in that posture where they don't have a court date or it's not showing up in EOIR, they can file it with USCIS and they can do it online.
We have a similar case last Monday for the Plaza guy that told us that I came through the border, but I wasn't registered. So, but I want to apply.
Yeah. So in that case, what Hector's saying is that there are still people who are able to cross and go undetected. So it sounds like that's what happened there. Those people have to apply with USCIS because they're not gonna have a nice check-in, nor do we advise anyone to go tell ICE like, hey, I'm here, right? There's no reason, you don't need to do that. But you are gonna be filing an asylum application, you're letting USCIS know that you're here. They don't tend to talk to each other. So it's unlikely that they're gonna have any issues with ICE anytime soon. But yes, they can file affirmatively. They don't have to have an A number. They file it online or they file it by mailing it to USCIS. Okay, so we're at almost at time, but how does someone find a lawyer to help them with their immigration case? So that brings us back to why Pro Se Plus exists in the first place, which is it's really hard. It's really, really hard to find a free immigration lawyer who knows what they're doing to help somebody with their immigration case. There are not enough immigration lawyers, and we're not like, I'm not saying we're the best people either to be doing this. I wish that our jobs didn't exist. I wish that this was, we didn't have to spend our Friday morning talking about all of this, right? But there's just not enough immigration lawyers. There's not enough free ones. There are, in the front, we've provided on locals referral sheets, so please feel free to take them. We can email them to you as well as to where we send people. It has our contact information as well. We are, on local is about 8 to 10 attorneys. You should know that. And we are each handling, almost 100 cases. So we just can't take them all. And we know that there are 50,000 people in New York, and that number is likely to continue to increase. And it's the same across the city. So we are giving you all this information so that people are not just completely without information when they are seeking help. Yeah.
If someone has found a lawyer that is charging them, is there a way for us to help them verify that it is a legitimate lawyer?
That's a good question. So every lawyer is registered with a license number, so you can look up that lawyer on. I always check the New York Courts website to see if somebody's attorney registration, there's an attorney directory there. So you can see if someone's on that website. It's nycourts.gov, and you just look up. What's that? Yeah.
There's also the district attorney's office website that allows you to put in the name of the lawyer, and if the lawyer is really registered in New York, then it will show. It will confirm.
But there's registered lawyers who are not good too. I don't mean to say that that's the end all be all, but it's not great, but like you can just do a Google search, like see what you can find about that particular person.
One of the specificities with the district attorney's office website is that if the lawyer has been disciplined, it will tell you how often he's been disciplined and where has he been disciplined before. So it allows you to know if he's safe or not.
So just to repeat that, on the New York district attorney, it'll depend on which borough, but each borough has a district attorney's office, and Cindy is explaining that you can check online, hopefully in all the boroughs, to see if somebody has been disciplined for unethical practice of law, which is different than unauthorized practice of law. I actually got to the end of my slides at 11:31, so I would love to take any questions, but also understand people's time, so feel free to head out if you don't have any questions and don't want to stay. But Blanca?
Just to go back to the issue of parole, so basically the length is discretionary, and there's really no way to renew or extend.
Well, if you look at ICE's website, it says, and it says this in some of the bounce back emails as well, if you email them and say, I'm trying to satisfy my reporting requirement, it says you can request extension of your parole at your next ICE check-in. The problem is that people are getting ICE check-in dates for like 8 years from now. So we're trying to create a way to bridge that gap. But it does say on ICE's website, you can request extension of your parole at your ICE check-in. But if people are not getting their ICE check-in dates, then it gets harder. But yeah, it's very discretionary right now.
I wonder, could you try saying that in the email?
Yeah, try it. Let me know what happens.
Right?
Yeah.
Are there any upcoming workshops on how people fill out forms?
Yeah, so we have several that we are working on. There is on Local's YouTube channel and on VIA's YouTube channel. VIA, Hector from VIA is here, one of the co-founders of Venezuelans and Immigrants Aid. We did a training with our legal director, Rebecca Press, that's we recorded on how to fill out a 589. And you can find that training on VIA's social media, on Local social media. It's the same video. And Rebecca actually checked yesterday, and there was 1,400 views on that video so far. So we just did that one a couple months ago.
Is that one specifically for affirmative or defensive?
It's the same. So it's the same application. The application is called the I-589. It has to be filled out the same way. It's just where it gets filed is what makes it affirmative versus defensive.
We're gonna have more workshops too, right?
Yeah, we're gonna have more workshops for you all. We have our next one. They're pulling it up right now. Our next one we're doing in March, May? April.
It's 1 a month.
Yeah. We will share it with you all, and hopefully you all provided your contact information when you came in today or when you registered in advance or online.
Will that included in the listserv? Because I got this email from somebody else, and so how do I sign up?
Yeah, so we will create a mailing list for everyone who's here, everyone who's online, so that we're sharing this all with you. I'm also part of something called the Bronx Immigration Partnership. So if you'd like to be added to that listserv so that you know what's happening in the Bronx around immigration-related meetings, events, resources, Mercy Center, MASA, many others are part of the Bronx Immigration Partnership, and it's been around for about 7 years. And so you're also welcome to attend those meetings. They're open to everyone, and they're usually online for Zoom right now. Blanca?
One of the issues like we're having with some of the people we see is that they have no idea the bureaucracy, okay? And they don't understand you have to do step 1, then step 2, then go back to step 2, then do step 3, then go back to step 1, and all this stuff. And they don't understand that, we're in a new world with capitalist bureaucracy, paperwork, get in the line and wait someone. So it's almost like they want this now, but I think community education has to be like the first step before we do applications. Because they just want this, but it's like, no, here's the system. Even us, I learned so much here today, and it's like we have to convey that to our community to help them understand why do we have to do this, and for them to understand the process, and not everyone will be the same.
Yeah, so here's what I would say to that. I 100% agree. And here's what I would say to that. The vision of this Pro Se Plus project is for you all. I'm going to share these slides with all of you. You can take everything I just said and repeat it back to the people at your organizations, right? I don't have any like sense of authority, of possession over this information. So I want you all, to the extent that you want to, and if you want some support, let me know. If you want to do this same presentation I just did in your organizations, please do, so that community education can be spread out. Blanca's talking about something different. She's saying like, okay, but we need to say that to the community as well. And we 100% agree, but we're trying to do both at the same time. We're trying to teach people who are filling out these applications and who are in removal proceedings the same information. We're delivering it mostly in Spanish. We're delivering this information. You guys got a slightly different version of it today, but you can repeat all of this to everyone that you are coming across. And if you want us to help support you, just let us know. Yeah.
Do you have slides for the presentation on how to fill out the application?
presentation for the participants?
For the participants, we do have, those are in the webinar, so the video that I just mentioned, and it's on our website as well. So we have them in Spanish right now, they're not in English yet, but we have them on Local's website. You can download the slides and you can view the presentation on our YouTube, and it's on our website as well, and on VIA's as well.
And I have the dates, finally.
Yes.
So April 3rd from 10 to 11:30 a.m. here in person. It's gonna be asylum overview and 589s. May 2nd from 3:30 to 5, also in person, and I'm assuming we're probably gonna have a Zoom option as well. It's employment authorization. And then June 14th, from 3:30 to 5 p.m., it's change of venues. And this one might also be hybrid, but still TBD.
Yeah.
Those are for us. for
Yeah.
learning
Yes,
to do
community
this.
advocates. One more time, April 3rd, 10 to 11:30 a.m., asylum overview and 589. May 2nd, 3:30 to 5 p.m., employment authorization. And June 14th, change of venues.
And we can
From
send that
3:30
out
to
in
5.
this big
Yes.
omnibus email that I'm talking about, that we haven't drafted yet. And I'm gonna send a survey also, so I would love for you to provide any input, feedback, things that are helpful, things that are not helpful. Please let us know, because we just started this literally 2 months ago. You know, all these organizations have been doing this work for a long time, but this is the first time we're working together in this way. We're learning on how to do it.
So I have, I think, 2 questions. This is kind of what we're already talking about, but I want to be really clear how I can get someone, help someone get started applying pro se. I point them to that video. Is there a way to connect them with an in-person workshop, or?
That's what we'll sort of be figuring out.
Okay.
So there's several events happening during the city already. NILAG, CALA, like key to the city events. There's one happening on Monday in the Bronx. And so there's different ways that people can get assistance through the regular mechanisms that the New York City has had. Now there's like capacity issues, but you can still try to call CALA and those numbers. We're trying to figure out how to centralize all the information in one place, in a website, so that everybody can see where are all of the like clinics happening. We're gonna have a clinic here hopefully in the future. So, you know, we're building as we're flying.
We're building the plane.
Completely, yes. Okay, would it be possible for maybe those numbers to go in an email,
Yeah,
or the names of those organizations? As of now, our organization is not yet letting us actually help someone do the application, so I want to be able to send people places, although I've also hoped that will change. Ask another one, which is, I've gotten mixed advice about when someone does not come up in the EOIR status checker, whether we should or should not do a change of venue. And sometimes they have an NTA in hand, but they're not coming up. And so, we better do a change of venue because they have an NTA, so we don't want them to miss their date. Or we shouldn't put them on the radar of the court if they're not already on the radar of the court.
Well, the court, so I understand your question. I'm going to repeat it back because it's a little complicated, and I may not do a good job, but I'm going to try. So if somebody doesn't have their A number showing up on the EOIR portal, remember that means their NTA, that is the ICE drafted and gave to them, has not been filed with that court, which means that that court doesn't know who that person is. So you can't really file a change of venue, because change of venue is it's a motion that gets filed with an immigration court that says, hey, take it out of this immigration court and put it in this immigration court. So you can't file a motion in a court that doesn't know who you're talking about, because ICE hasn't taken that NTA and filed it with the court. So you can let the court know what someone's address is using that form that I mentioned.
33.
Let me get it. The EOIR 33 change of address form. But that is not the same thing as filing a motion to change venue. A motion to change venue is a very specific type of remedy in which you're saying to a court, I know that I have my court appearance in Texas next month, but I don't live in Texas anymore. Can you please move my court appearance from Texas to New York? That's where a motion to change venue becomes relevant. But you're not going to file it if there's no hearing. If there's no upcoming hearing, then there's no reason to file a motion to change venue.
I have 2 questions. One, what are the possibilities of when a client comes in and they've already missed their 1-year filing deadline?
Oh, when you're filing deadline.
Yeah.
That's not what they're doing. They should still file, if they want to file for asylum and they've missed their 1-year filing deadline and they believe that they're eligible for asylum, they should still file their 589 because there are exceptions to the 1-year filing deadline. There can be exceptional circumstances. Something was going on, like 50,000 people all trying to file at once. So they should still file it and be able to explain what those exceptional circumstances were, or changed country conditions. So if something happened in someone's country and they're able to explain, like, I didn't file it then because that stuff wasn't happening in my country, that's happening now, then they can explain, I'm filing it now because of those changed conditions. Actually, it's changed circumstances, which also often includes changed country conditions. So, but some circumstance has changed. One example might be somebody is trans and they decide to transition. So that's a change in circumstances. So then maybe they didn't file their 589 before they transitioned, and then the change in circumstances is the transition. So if they are filing after their 1-year filing deadline, they can explain, I should be eligible for this exception. There's a second question?
No, the second one was just more information on March 15th. The trainings that we're doing, just how we have the YouTube and the recorded video of how to file pro se. We have another one coming up on March 15th for folks to know about their representation in courts.
Any other questions? Yes.
I'm sorry, I have so many questions, and this may be for another training because I know what we are talking about here is asylum. But I'm wondering, what are the other forms of relief? Like, he's gonna say, oh, what forms of relief is the person interested in? But what options?
There are many forms of relief.
It seems important to know because so many people will not qualify for asylum.
Yeah.
Even if they are in danger, but it's not specific persecution.
I'm not gonna answer that question because it's too hard to answer it. It's very, very specific, person specific, case specific, country specific. When they entered the country is specific, age specific. There's a lot of things, but that doesn't mean that I will never answer it. That would be a different training.
Sounds good to me.
But the screenings are meant to help with that too. The agencies that are doing this right now, they always are screening people, so they're trying to look out for that too.
Okay, thank you, everybody. Thank you, everyone online.